Hello class, greetings to you all. I hope that you are able to see me. I'm trying to do this a little bit differently today so that the screen and that you are able to access the materials more effectively, because otherwise it might be, I'm aware that it might be difficult for you to actually view some of the material that I'm referencing. All right. Anyway, welcome to the class. This will be the 9th session that I'm having with you for public law revision. Okay, the topic today is ministerial responsibility and accountability, and the handout that you will require is, you could have perhaps printed it out. That would have been helpful to you. I posted these notes last Wednesday I posted it. So your handout should consist of 10 pages, okay? And I will be making reference to this as I go along, all right? So if you look at the topic for today, it is ministerial responsibility and accountability. The question that we are going to start off with is this one, which is last year's Zone A question, 2019 Zone A, question 4. Discuss the range of individual and collective responsibilities of government ministers, together with the means by which they are established and enforced. Now, that's quite a nice question, which requires you to look at two things, or there should be two parts to your answer. Let's have a look what you should be examining. The first part, which I have put here, is that note that the question is on both CMR and IMR, all right? Because it says the range of both individual and collective responsibilities. The second part asks you the means. The word means is methods. That means it's asking you how the conventions are two things. How are they established? That means how are they formed? And how are they enforced? Remember that these are conventions. So because they are conventions, they will not be enforced by court. So what is the method of enforcement? How would we enforce them? Now, if you look at the general remarks by the examiner, the University of London Examiner's report says that the question is on scrutiny of the executive, Parliament's scrutiny of the executive. So you know that on the topic of Parliament, there are two types of areas that can come out. It could be Parliament's legislative work, that means the lawmaking work, or it could be Parliament's job of scrutinizing the executive. So this question is on the latter, is on scrutiny of the executive. So the first general remark says Parliament performs a number of roles. One of them is supervising the executive. The question is also telling us, or asking us to look at, what about the effectiveness? How will this job be done well? Scrutiny. It will be done well depending on the doctrine of ministerial responsibility. Note that the House of Commons at the end of the day can require the government to resign, but all these powers are governed by convention. There are also several written documents in the form of the Ministerial Code, the Cabinet Manual, but these are political documents. They are conventions recorded in these codes. Now, so common errors and a good answer to this question you can read for yourself. I won't waste your time with that. Please do have a look at that. I've included it because this is something that the University of London Examiner's report highlighted. Right. So in my suggested approach, there are about 7 parts to my answer. First, as always, I would emphasize this: respond to the question. Second, explain the need for parliamentary accountability. Third, go straight to the conventions. I am starting off with CMR. So number 3, I look at the Convention of Collective Ministerial Responsibility. Going now to page 2, once I'm done with CMR, number 4, I come to look at IMR, the Convention of IMR. How does it work? When I talk about these conventions, please remember, I would like to reiterate, it's not just about the conventions. I must look at this. So when I talk about CMR, I must look at enforcement, all right? When I talk about enforcement, yeah? And when I talk about IMR, again, I must look at enforcement, okay? So once I'm done with that and I give some examples, the first method of enforcement that I would talk about is resignation. I then would give some examples. And then I come on to page 3, I go to number 5, and this is really the second part to my answer, which is what are the methods of accountability? I would look at the Ministerial Code, and then I would also look at other methods of enforcement. Okay, so resignation is one that we've already talked about, but there are also others. We would have a discussion. And then I would also ask, well, if you look at all these methods of enforcement, it's nothing to do with the courts. But does the judiciary play any role here? So here I would compare and contrast the approach of the judiciary, Chief Justice Widgery, in the Jonathan Cape case way back in the late 70s to Miller number 2 in 2019. And I would ask the question, which I've posed here, can it be argued that there is an indirect enforcement of the Convention of Parliamentary Accountability in Miller number 2? And is this the norm or is it a one-off? So that will give my answer a nice little twist. And then I come to number 7. Do we need any reforms here to make enforcement more effective? For example, under reform, perhaps you can talk about the issue of whether or not, all right, let me just type this here, codification, okay, is that desirable? Okay, so would codification be a good thing? That could be something we could talk about in reform. And finally, conclusion on this question. So that would be how I would answer this question, all right? In about 8 parts, 7 or 8 parts, yeah? So let's go back now to page 1. So the parts that I've highlighted are the different steps to answering this question. So as I said, number 1, respond to the question. What does that mean? All you need to say is to indicate that to the examiner that you have understood the question. So all you need to state, because this is not a provocative quotation which you're responding to, it's just a straightforward question asking you what's the range of individual and collective responsibilities and the methods by which they are established and enforced. So under number 1, you can say something as simple as this question requires me to look at the range of ministerial responsibilities, collective and individual, and the methods by which they are established and enforced. To make your answer more interesting, you may also say that this answer will argue that the methods of enforcement are defective, and this has resulted in, at times, a lack of enforcement of ministerial responsibility and accountability, which is why writers such as Colin Turpin, Turpin, have argued or raised the question whether ministerial responsibility is a myth or reality. So these could be some of the things that you talk about under number 1. Number 2, you ought to explain the need for parliamentary accountability. Now, what do I mean here? In other words, the importance of this, that an elected official is answerable for every government decision, all right? Is also important so that their activities are monitored within the departments. So each cabinet member answers for their own ministry in Parliament's question time. Of course, the reverse of this is the neutrality of the civil service. So the civil service is not elected, that's why they're not accountable. The ministers are elected, their mandate to govern is from the public, that is why they are accountable. It is part and parcel of the concept of parliamentary democracy. Right, good. So that brings us to number 3. So we now talk about the Convention of Collective Ministerial Responsibility. Now, explain that this only concerns ministers in government serving within the cabinet. It dates back to the 18th century. The principle, or the convention rather, states that members of the cabinet should support all government decisions. Please note that it's a convention rather than a legal requirement, but still members are, I beg your pardon, ministers are expected to show what we call a united front. A united front. Now, what is the meaning of a united front? Why should you have a united front? To project unity to the public, so that there will be a feeling of confidence, so unity to the public. All right, so that means that decisions taken by the cabinet are binding on all the members. Now, of course, in reality, cabinet ministers are not robots. They may disagree in private. Let's consider the situation in the UK at the moment. The COVID pandemic is going on. Now, last night I logged on to BBC and I saw that Boris Johnson has been declared positive, has been tested, I beg your pardon, positive for the COVID virus, and he says that he's working from home, and he's now decided that the government is going to send letters to every single household, more than 30 households, all right, a letter to say what they're going to do about the COVID. Some people have responded to that by saying that's going to cost almost £6 million sending letters to people's houses. Why don't you just announce that on the TV? Why do you want to need to go and send letters? How old-fashioned is that? So not everybody agrees. But if a cabinet minister were to go and publicly denounce Boris Johnson for saying that, they would have to resign. Yeah? Because you can't do that. You can't just attack the prime minister like that. If you do that, the prime minister may ask you to go and resign, all right, or ask you to get lost, because it's an attack on his credibility. So you must provide a united front. That means that even if you disagree in private, you should not voice that in public. Let's go on now to page 2. Now, let's give an example. All right, we see the highlight here. So I put Robin Cook and I put there, yes. This is to give an example of the convention of CMR. What happens, I said just now, what happens if you don't agree? And I said that, you might have to resign. One good example of that was in 2003, Robin Cook, as leader of the House of Commons under the Tony Blair Labour government at that time, he was unable to publicly speak out about his objections to the war in Iraq. And following this convention, he resigned from office and he spoke from the backbenches in the House of Commons of his disagreement. So that's a good example. So let's come to this, enforcement, all right, enforcement. So who will enforce CMR? Now the answer is it's largely up to the Prime Minister. Okay, it's largely up to the Prime Minister. So to be the Prime Minister who will enforce the convention, yes, and sometimes the Prime Minister might do that quietly. Sometimes the Prime Minister might get very angry and ask the Minister to just step down. Now, are there any exceptions to this? And the answer is yes. There is the exception of, I don't know why that's doing that. Okay, sorry about that. Are there any exceptions? Yes. There is the exception of an agreement to differ. So, which means that sometimes the Prime Minister may actually suspend CMR and say that there is an agreement to have a differing view. Now, in the UK, this has only happened in very limited occasions. For example, on the issue of tariff policy in 1932, alternative voting systems during the coalition agreement. Why? Because Nick Clegg wanted to have a referendum on the alternative voting system, and David Cameron did not want to. So they had an agreement to differ. and also over referendum pertaining to the EU. In 1975, there was an agreement to differ. In 2016, again, there was an agreement to differ. So this is the convention of CMR. That's how it works. We've given examples, we've spoken about enforcement, we've also spoken about exceptions. Let's now turn to number 4. Let's go to the convention of IMR, individual ministerial responsibility. Please note, we said that this covers both official misconduct and also personal misconduct. Now, what is official misconduct? Official misconduct is where there is any behavior which has been found to have occurred within the ministry. The minister is responsible even if the minister had no knowledge of those actions. This is to be contrasted to personal misconduct, which is about the personal culpability and the personal behavior, either the person's actions or inactions of the minister himself. Usually personal misconduct relates to, for instance, sexual impropriety or financial impropriety. Next, so how is the convention of IMR enforced? So if you look under enforcement, you will see that the doctrine is a convention, so there is no formal mechanism to enforce it. Sometimes today, ministers frequently use ignorance of behavior to say that they're not going to resign or they were not aware. So what are the guidelines? Let's look at resignation first as a method. Now, way back in 1954, the Crucial Down incident happened and Thomas Dugdale resigned, although he himself was not personally responsible for what had happened in the Department of Agriculture, but he said that he would take that responsibility and step down as a result in order to give that protection to his civil servants. So guidelines set in 1954 may not necessarily be followed today. So there's been a lack of a clear pattern where resignation for IMR is concerned. And we see that in some instances, for example, in the Falklands Affair in 1982, Lord Carrington, who was then Foreign Secretary, and 2 other Foreign Office ministers resigned shortly after the Falkland Islands was invaded. All right? And Mrs. Thatcher at the time actually said there was no need for him, Lord Carrington, to resign. But he did, because he felt that it was necessary, it was the honourable thing. Now, this incident where Lord Carrington resigned in the Falklands Affair must be contrasted to the next example at the bottom of this page, all right, page 2, which is the Maze Prison Affair. Now, the Maze Prison Affair, when that happened in 1983, when 38 IRA, that stands for the Irish Republican Army, prisoners broke out of, the name of the prison was the Maze Prison, simply because inside, you know, they had a lot of structures that resembled mazes. The Secretary of State for Northern Ireland, Secretary of State means the minister, James Pryor, he said, I'm not going to resign. He even said that, and let's just put a notation there so that you remember, all right? He even said, let's see whether, does this allow me to do it? Yeah. So he even said, just a second there. Let's see whether it allows me to comment as I go along. No, it's not allowing me to do that. Okay, never mind. So James Pryor, he did not resign, explaining that the break was not caused by, no, I can't comment on it. It's all right. Maybe you might want to write with a pen or something. Now, he did not resign. And what he said, this is what I wanted to post, but it's not allowing me to do that. He said that there was no constitutional duty to require him to resign. In other words, James Pryor was saying there is no constitutional principle requiring a minister to resign. So that, of course, you know, makes us think, because James Pryor said, I was not responsible for these fellows running out of the prison. It's not as though I turned the key. all right, and let them all escape. So this tells us the difference between responsibility on the one hand, whether a minister is personally responsible, and accountability, all right, and accountability. Accountability means having to answer anyway. The best example that comes to me is, for example, let's say what's happening to us at the moment. I'm the teacher, you're the student. So we can't have a proper class because of the MCO. Now, I'm not personally responsible for that, neither are you, right? ATC is not responsible for the MCO. But we are accountable, aren't we? We are accountable to give you an answer as to, okay, the revision can't go on. What are we going to do about it? So we have to come up with perhaps an online method. We have to come up with a method whereby we help you to understand. We post answers. So we may not be responsible for the CMO, but we are accountable to students as to what we're going to do about it. You see the difference? Responsibility and accountability. All right? Now, next. So, examples of resignations in recent cabinets. In Theresa May's cabinet, you might want to give examples of Priti Patel, who resigned in November 2017, the Secretary of State for International Development, following revelations that she had held unauthorized meetings with Israeli ministers. Michael Fallon, the Secretary of State for Defense, also resigned in November 2017 because he had been accused of improper and inappropriate behavior towards a female journalist more than a decade before. Recent administrations, that's both Theresa May and Boris Johnson, all right? In 2019, 26 ministers resigned from office, all right? And of these, 6 cabinet ministers and 16 other ministers resigned over the handling of Brexit, okay? So Brexit resulted in many resignations, okay? So of these 6 cabinet members and 16, that's a lot, huh? So 16 plus 6, 22 ministers have resigned over Brexit, 22, okay? 4 other ministers, I'm going to page 3 now, left government, 3 resigning for personal reasons. So personal reasons means personal misconduct, 1 being dismissed over a security breach, okay? So Michael Fallon would be for personal reasons, okay? Now, an argument put forward now during the Scott inquiry to the arms Iraq affair. This is what I told you about the difference between this word, responsibility and accountability. So even if you are not responsible, yes, you must be this accountable. Okay, right, good. Now let's come on to the 5th part of our answer, which is methods of accountability. So what are the methods of accountability for these conventions? Very important, the Ministerial Code. Here I want to make a note to you to see page 8 for further elaboration of the Ministerial Code. All right, see page 8 for further elaboration of the Ministerial Code. And you will see, if I just quickly go down to page 8 so that I can tell you about it. It's page 8 of the same handout. Another question here, I've referred to the Ministerial Code. If you look there, so it's a parliamentary document to help to enforce the convention. Do you see that? It's a parliamentary document to help to enforce it. So the Ministerial Code, do you see that? I'm highlighting it with you. Yes. So it endorses the principle of, if you look here, collective responsibility. Yes, so the principle of collective responsibility applies to all government ministers. Ministers have a duty to Parliament to account and to be held to account for the policies, decisions and actions of their department and agencies. So A is CMR, B is IMR. So who actually comes up with the Ministerial Code? It's the Prime Minister of the day. Okay, so ministers under Part C, it is of paramount importance that ministers give accurate and truthful information to Parliament. Please look at what I've underlined. Ministers who knowingly mislead Parliament will be expected to offer their resignation to the Prime Minister. So this tells us 2 things. It tells us, 1, that resignation is an important method. And it also tells us that it is the Prime Minister, yes, the resignation is made to the Prime Minister. You see there? So it is the Prime Minister who actually enforces it. So what is the legal status of the Ministerial Code? Is it a political convention? Yes, it is. It's a convention that has been recorded in a document in Parliament. Look at the next question. Can it be enforced in a court of law? My answer would be no. It can't. Then what about the next question? How effective is this code as a parliamentary method or mechanism of ensuring responsibility or accountability of government ministers to account for the policies and actions of their department? Now, we must be careful not to dismiss the code too lightly. The code is important, but it is up to the Prime Minister at the end of the day to enforce it. Okay? All right? It is not something that can be enforced in court. Now, what about some other methods of accountability, parliamentary practices and procedures in the House of Commons? What about parliamentary questions, number one? So, questions, I'm going to page 9, may be asked orally and in written forms. And in the Commons, the first hour of business on weekdays is kept for ministers answering oral questions from MPs. There's a rota. Now, what are the problems here? There are always more MPs than can be accommodated in the limited time. So what's the answer? MPs have to enter a ballot. They can only ask questions if they win a slot. Another problem is time. There's limited time. And another problem is the effectiveness of question time. Sometimes ministers will have advance notice of what questions they'll be asked. Next, number 2. Another method of accountability to enforce the convention is Prime Minister's question time. And this happens every Wednesday afternoon. 30 minutes now is actually gone up to 45 minutes. And if you look, one example, there are many examples because it happens every week, but I remember watching this in January 2018, how Theresa May was grilled over Brexit from even both wings of her Conservative Party. And at the moment, March 2020, now Boris Johnson has gone into isolation now, having been tested positive for COVID. But before that, he's also in the grill hotspot because he must explain to Parliament and the public what policies the UK government will be adopting to combat the COVID menace. So that is PM's question time. Parliamentary debates, third method. There are also debates on the floor of the House of Commons. All right? And that's also a method for the government to account for their policies. There are also select committee inquiries, also known as parliamentary select inquiries, select committee inquiries, PSCs. Now, if you look at the Trade and Industry Select Committee that investigated the Matrix Churchill arms to Iraq scandal in 1992, what were some of the problems faced by the committee then? You may recall 2 particular problems, which are, and we saw this also with the Edwina Currie Salmonella Parliamentary Select Committee. What are the problems? Lack of attendance, number 1. In other words, you cannot force members to attend. So attendance, competence, compatibility, you can't force them. You also can't force them to cooperate with the proceedings, and we saw this with the Edwina Currie example. And then if you look at a recent example, the scandal over Facebook recently, whereby Mark Zuckerberg for a long time decided not to appear before MPs despite repeatedly being asked to do so, all right, by the Parliamentary Select Committee of the Department of Culture, Media and Sport Select Committee. So I've asked the question, what does this illustrate about the problems faced by select committees, which are those: lack of attendance, attendance is one, competence is another, compatibility, lack of, you can't force them to willingly take part or to give accurate information. You're really relying on their willingness to cooperate in a sense. So it's limited. All right, it's not like a situation where if somebody doesn't attend trial, you can be subpoenaed to court, but that's not the case here. So these are some of the weaknesses of the system. Another method of accountability is by backbenchers. Backbenchers may also ask questions, so may members of the opposition. So these are all methods, these 6 methods. Now let's go back to those 6 methods. What are they? Parliamentary question, PM question time, parliamentary debates, select committee inquiries, backbenchers, opposition. All these are methods of accountability inside Parliament. There are also methods of accountability outside, which is public inquiries, whereby you have, usually it's a retired judge, and he set up to head a commission which investigates into scandals that have occurred. So the Chilcot inquiry, for example, the Hutton inquiry, for example, these are examples of inquiries into scandals occurring within government. But again, the criticism over these is that these reports are only of a political nature. They're only persuasive. They might embarrass the government. But by the time that the report comes out, sometimes it's more than a decade, after the scandal has happened. All right. So if you look at the Chilcot inquiry reported in 2016 over the Iraq War, which was in 2003. So that's 13 years later. People forget. The Prime Minister at the time is no more the Prime Minister. Time has passed. So these methods are not, public inquiries are not that effective in terms of creating responsibility and accountability, in my opinion. So let's go back to we were just now on page here, all right? So I've come back to page 3, all right? So if you recall, I was looking at methods of accountability. I looked at Ministerial Code. I then said that further, notes on page 8. I then referred to that. I then came to this, other methods of enforcement. And I then, on other methods of enforcement, I looked at these methods. So note other methods of enforcement, resignation. I'm just going to type that here. Resignation, bear with me a minute, is only one method. Remember that. Okay, so resignation is only one method. We looked at resignation, but we also looked at all this. So Q&A sessions, debates, parliamentary select committees, all this, yes, we said that, well, I can't type it here, but I cross-referred to your, for other methods of enforcement. Perhaps we'll put it here, okay, so that when you are, resignation is only one method. Okay, please refer to pages, that will be 8 to 10 for further discussion. And that's what I referred to just now. Okay, all right. So I looked at all this. If you looked at resignation, Q&A, debates, parliamentary select committees, opposition, backbenchers. Now, all these are methods in what? Parliament. Public inquiries outside Parliament. Judicial approach. Now, what happened in AG and Jonathan Cape? In AG and Jonathan Cape, the convention here was with regard to cabinet secrecy, all right? So AG and Jonathan Cape was about the Crossman Diaries case, and after Richard Crossman had passed away, the administrators of his estate wanted to print his diaries. The government wanted to stop that and claimed that the Convention of Cabinet Secrecy would be violated. The court said that, and Chief Justice Widgery emphasized here that cabinet secrecy is only a convention and the court won't enforce it. This is a very different approach compared to Miller number 2. If you recall, in Miller number 2, the issue was the prorogation of Parliament. If you remember Lady Hale and what she said that there are two very important principles of the Constitution which are affected here. One would be parliamentary sovereignty. The other one would be parliamentary accountability, and how it was imperative that Parliament scrutinize the executive and that the Prime Minister and his team must explain and account for policies leading up to Brexit. In this, really, we may argue that there is an argument to say that by doing this, Lady Hale may actually be indirectly enforcing the Convention of Collective Ministerial Responsibility. Yes, that Boris Johnson and his government must be able to stand up in Parliament and explain their stance over what they were going to do with Brexit. If they were to go and prorogue Parliament, they can't do that because everything would be shut down, a bit like a lockdown. So then, how would you be able to scrutinize anyone if we are under lockdown? It would be very difficult, wouldn't it? So Lady Hale said that it's a one-off because she knew, and the Supreme Court knew, that the circumstances of the case were so unusual. So the decision is extraordinary because it was an extraordinary time. So that's why Lady Hale said it's a one-off decision, but I would still maintain that we see here an indirect enforcement of the Convention of Parliamentary Accountability. And this is an argument that I explored in my videos on constitutional conventions, and then again when I looked at prerogative powers. I'm not sure whether you have viewed those videos, but I hope that you do, so that you can understand and explore this argument further. Once we're done with that, I beg your pardon, 7, reform. I've put here, you might want to have just a couple of lines on whether, since the question is on enforceability, would it help if we codified the Convention of Ministerial Responsibility? Would that lead to better enforcement? You could look at some of the arguments for and against. I personally think that, to codify it into an act of parliament is not really going to make much difference, because at the moment, in a sense, it's already codified, except that it's in the ministerial code and the cabinet manual. It's a code of a different nature, all right? But it does indeed help those in parliament. Whether we need something to be enforced by the court is a different matter. And if you recall what I said just now about what Lady Hale said, she does seem to be suggesting that, well, she's not suggesting, she expressly says that it's a one-off case. So I'm not sure whether the courts would be, even the Supreme Court, whether it would be happy with enforcing ministerial responsibility all the time. Lady Hale did indicate it was a one-off. So conclusion, therefore, as this answer illustrates, the conventions of collective ministerial responsibility and individual ministerial responsibility are crucial in the workings of government. Nevertheless, they don't always work to perfection. They don't always accord to the theory, and the methods of enforcement sometimes are not as effective as they could be. All right. Thank you for your attention. That brings me to the end of this video. That's about 35 minutes, so I shouldn't really go any longer than that, because that's too long to expect you to concentrate. I'd like to thank you for your attention if you've been with me till the end of this video, and I will look forward to see you in the next video. All right, so I'm going to end this now. Thank you. Bye bye. Take care of yourself, and I hope to see you soon. All right, bye bye.